Alrighty, this episode is really going to be a replacement of the last Torts episode of Ispa, Loquitur. And the reason for that is because it's really building off of all the cases we talked about yesterday, and it's going to work hand in hand with the other one. So if you want to listen to that episode, that'll work. If you want to listen to this episode, that will also work. Just to go over all the cases that we talked about, there is Burn v. Brodel, which is the sack of flour. That was the first case. Sack of flour fell down on somebody, sued I won't get into all the details. Anyways, Burn v. Bodel, McDougall versus Perry, Larson versus St. Francis Hotel, Cruz versus Daimler Chrysler Motor Corps, James versus Wormuth, and Sullivan versus Crabtree. Really big takeaways from this is that there's no such thing as a good res Ispa Loquitur case. If you can find proof of negligence anywhere else, you should find proof of negligence anywhere else. However, if you are limited to using res Ispa Loquitur as your claim of proof of negligence, then here's how you would ultimately prove it. So, res Ispa Loquitur is circumstantial evidence is better than eyewitness evidence in the sense of eyewitness evidence can be unreliable, but circumstantial evidence, you can make inferences about what happened based off of the facts of the situation. And so it is more reliable, even if it doesn't seem like it might be as strong. But res Ispa Loquitur is when it's one way to prove that there's circumstantial evidence. So we need to ask, in order to find whether or not this doctrine is met, is whether more often than not, would this have occurred, or would this rather not have occurred, had there been any negligence? Meaning, would this have occurred? Meaning, if negligence had not happened, would this have occurred? And if the answer is no, then there's no negligence. But if the answer is yes, meaning if there is negligence and this does happen, well, then you can have a case for res Ispa Loquitur. Evidence. Oh, and then the second element is that the evidence needs to point to the defendant being the responsible party, meaning that the defendant needs to have control over the thing that ended up causing the injury. So most of the time, this is actually going to need to be established by an expert witness. For example, a mechanic can show why something occurred, why something came apart, something exploded, whereas a common person would not know. And you see that where, like, for example, airbags go off. A mechanic is going to know why airbags went off. What was the cause? What was the reasoning? Was there negligence involved? And you can say more often than not there is negligence involved because negligence equals airbags going off when they're not supposed to go off, at least. But in order to find this, you actually first need to convince the judge that there is a case for res Ispa Loquitur. And if that is met, then there's going to be effects that go to the jury. And the jury can hear that case to make up their mind. So there are three possible effects. I just said one is that there is an inference of negligence that can be drawn by the jury. Second possible effect is that there's a presumption of negligence on the defendant, and the defendant needs to rebut that presumption. And then third is that the defendant has the burden of proof to show that they were not negligent, meaning you need to say, here's what I was doing at this time. There's no way that I could have actually been the cause of this. I had no control over it. Most of the courts are actually going to follow this first approach, though, because second and three are just kind of a little out there. And really what that is that an inference of negligence can be drawn by the jury, but they do not have to make that inference. And the defendant in that situation is going to come up with as many possible explanations as they can to say, look, it could have been this, it could have been this, it could have been this. And the plaintiff's going to be like, no, it was this. And so that's where the litigation is going to go, is trying to persuade the jury to go one way or the other. What's more likely to have occurred? So, once again, big takeaway from this is that more often than not, you're going to lose your res ispa loquitur cases. They're really poor cases to litigate, and they're really poor cases to negotiate. Meaning, if you're claiming a res ispa loquitur case, the other side knows that you have a poor case. And so, prior to that, it's really hard to settle. And then, after a judge says that there's a res ispa loquitur case, it's really hard to settle. And that's the biggest takeaways from this. Once again, res ispa loquitur is just Latin for it speaks for itself. Meaning, if you want to try to picture this big picture, the circumstances of the case just showed that there was some negligence there, because those facts would not have happened had there not have been negligence. Meaning negligence equals thing happening. And there's no other way that it could be interpreted. And that's res ispa loquitur. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is, if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.